Hi, I'm Shan Wu with an Undercolor of Law hot take on the start of the Hunter Biden trial. So it's off to a really bad start for Special Counsel David Weiss. Even though this case looks like it should be a slam dunk case because Biden's already admitted he was using drugs at the time and he's admitted he bought a gun, and that's what the case is about, that he supposedly lied on the gun purchase form about whether he was a drug addict or using illegal substances at the time he bought the gun. Now, I mentioned before that jury nullification might be an issue in this case, and I want to dive a little bit deeper into that in light of what happened today during the opening arguments. Now, the strict definition of jury nullification, and we're going to put that up for you, is that even though there is evidence that proves guilt beyond a reasonable doubt, even though the law says that the person should be convicted, the jury chooses not to. They either refuse to apply the law or they reject the evidence because they want to send a message about a bigger social issue or because they feel that a conviction would be contrary to the jury's sense of justice, morality, or fairness. That's the strict definition of jury nullification. So let's be clear, juries aren't supposed to do that. They're supposed to follow the law and apply the law to the evidence. And the definition of nullification does conjure up images of a jury making some sort of a stance, a social justice inspired speech. But the reality of the nullification is very different because the jury doesn't have to make some sort of blatant statement. They don't even have to think of it as actually nullifying the evidence or refusing to follow the law. Rather, this atmosphere that can contribute to a nullification can cause the jury to look for particular parts of a defense that can counteract the strong evidence for the prosecution. Obviously, they could also just hang instead of acquitting. But as I said before, hanging juries are not that common. They usually will reach a verdict. So a skilled defense counsel can bring out factors that contribute to nullification, which is basically trying to make the case seem unfair. And a skilled prosecutor needs to guard against that. So far, this is beginning to look to me like a poster child case for nullification. The prosecution seems badly mismatched. Defense counsel Abby Lowell is a very experienced white-collar defense counsel. He's represented both sides of the aisle, Ivanka Trump, Jared Kushner, and sort of interesting trivia point, he is the one who had represented former presidential candidate John Edwards in the campaign finance case that was brought against none other than Jack Smith. And he got an acquittal on that. Edwards skated on those charges. So faced with this apparently strong case, which is that is very well known, Hunter Biden was using crack cocaine at the time he bought this gun, and he checked the box that said he wasn't using drugs or a drug addict. Lowell surprised me. He focused on a very important part of the requirements for the false statement, which is that it had to be knowing. And he said in his opening that the prosecution was sort of shying away from the word knowing. And it's very interesting because obviously there's a common sense appeal that someone who's heavily using drugs or is addicted may have a hard time thinking very clearly. So you might also be able to attack the idea of, was this really a knowing sort of intentional act he did, or was he sort of like, in a sort of a drug-induced, hazy kind of state? But it goes beyond that. They're setting up a defense theory that on the specific date Biden bought the gun, where he checked the box that he's not using drugs, he had actually recently finished an 11-day rehab program. And so the theory there would be that he genuinely believed that he wasn't using at that time. He wasn't a drug addict. He just gotten out of rehab. Now, one interesting fact, which makes me think it's a poster child case for nullification, is that during Abby Lowell's opening statement, one of the jurors apparently was crying. They were dabbing at their eyes, looking very emotional. Now, don't know why they were doing that. Maybe they had allergies. But certainly, if you're a defense counsel and you manage to get somebody on the jury crying in your opening statement, that is not something that the prosecution is going to be happy about. Likely, they were upset because they're feeling some empathy because they were talking about the addiction cycle that Hunter Biden had been in, as well as the well-known previous traumas he'd experienced, such as the childhood car crash that killed his mother and sister that he and his brother Bo survived, and then Bo dying from brain cancer in 2015. The issue of the drug addiction really cuts both ways for the two sides. I mean, on the one hand, it's very easy from Biden's own admissions that he was using drugs, and that seems really easy to prove that aspect of the case. But for the defense, they need to figure out how to counter that. And so for that reason, some of the questions asked during the jury selection process to voir dire really went to this. One of the questions asked was, they asked for a show of hands if any of the potential jurors or their families had been affected by drug addiction. And according to reporting, all but a few did say, yes, they'd been affected by it personally, or they knew someone or their family had been. So just asking that question is kind of a lose-lose proposition for the prosecution because of two things. First, that overwhelming response, which it ends up apparently from reporting that some 50% of the people who made it onto jury had all raised their hands, that makes it really plain to the defense who on the jury has had this type of personal interaction with the disease, the tragedy of drug addiction. That gives them a big upper hand in knowing who they want to play to when they're making the arguments. Now, making things a little bit worse from an atmospheric point was that the prosecution, I think this was a mistake, began their evidence presentation by playing excerpts from Hunter Biden's autobiography, the memoir called Beautiful Things. And they played it from the audiobook version. Now, I can see why they thought this was a good idea, right? Because Biden has a constitutional right not to testify. Maybe they won't hear from him. But here, you get to hear his own voice. He's reading it, admitting his use of drugs, and he describes, apparently very dramatically, a very painful descent into drug addiction following the death of his brother, Bo Biden, from brain cancer. Now, here's how that may have backfired. As they played this recording of Hunter Biden's voice talking about what he'd been through and went on for about an hour, different excerpts, in the audience there to support him was his sister, Ashley Biden, and the First Lady of the United States, Jill Biden, who had raised him. They were there to support him as well as his wife and a friend. And during the playing of that, apparently it was very hard to listen to. I mean, can you imagine? And that his sister was dabbing at her eyes. And at one point, the First Lady put her arm around Ashley Biden's shoulders. That's not going to be lost on the jury. I mean, they're going to recognize the First Lady. And there's a special place in American consciousness for First Ladies. It doesn't matter how unpopular their husbands can be. Even sometimes when they're unpopular, there's still a lot of deference given to a First Lady. And here, it's not just that she's the wife of the president. She's there very much in a mother role, in a motherly figure. And that's going to be a big atmospheric in the courtroom. But the prosecution is obviously putting this on because they consider it to be a confession. And they're kind of bludgeoning their way to this idea that even though the defense may be on the particular day that he checked that form, he genuinely didn't believe he had a drug problem. To counter that, the prosecution is, as I'm saying, bludgeoning their way through it by putting on so much evidence about his drug addiction that their point is, this whole time he was constantly using drugs. It's overwhelming. It's ridiculous that there was one day where he genuinely believed he wasn't a drug addict or using drugs. However, they already ran into some problems with that because the FBI agent who was testifying today on cross admitted that the agent felt there were times during this 4 or 5 year period that Hunter Biden was using drugs that he probably wasn't using drugs. Makes sense. I mean, you're not necessarily constantly in that using state, and particularly if there's documentation that he'd gone to rehab before. So those are some of the issues already being faced by the prosecution here in the face of a very skilled defense opening and a very coherent counter-narrative, which is that hey, you have to show that he knew he was lying on that form, and on that day, he didn't really believe he was lying. In the end, if there is an acquittal here, the seeds for that may really have been provided by the prosecution in their opening statement. Because in their opening statement, the prosecutor asserted to the jury, quote, addiction may not be a choice, but then said buying a gun is a choice, and that Hunter Biden isn't charged with possessing drugs. Following up on this, really important point, the prosecutor stated, quote, we would not be here today if he, Hunter Biden, was just a drug addict. If there's an acquittal in this case, that's going to come back to haunt him, because first, by framing it that way, it causes the jury to wonder why the prosecution can say, oh, addiction's not a choice, disease, can't control that. But on the other hand, you want to say that the addict can control decisions like buying the gun, checking off boxes. It's basically asking them to conclude that sometimes addicts cannot control themselves, but other times they can. But it's the second point that's really dangerous for the prosecution and goes to the nullification concept, which is by asserting that Biden, quote, would not be here today if he was just a drug addict. That's really shouting out the fact that he's not, quote, just a drug addict. He's the son of a sitting president. And by that statement, the prosecution is all but inviting the jury to wonder if any other drug addict would even have been charged in these circumstances. That is why the case at the moment is a poster child case for jury nullification, and we'll have to see how it continues to progress. So that's a quick take on the opening of this very historic trial. And I'm Shan Wu. Thanks for listening. Thanks for watching. And I look forward to getting more comments from you, because it really helps to know what is helpful, what other kinds of things you'd like to hear about. Thanks.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.